All right, so the time I have by my computer is 12:45. Waiting for a few more folks to drift in. And I did see Judge Flood previously, a few minutes ago. There she is. All right, welcome back, everyone. We just are returning from our lunch break. Time is 12:45. We're ready to begin with the cross-examination of the witness. Ms. Rasnick, are you ready to go?
I am.
All right, Ms. Bremner, are you ready to go?
I am. Thank you, Your Honor.
All right, please proceed, Ms. Rasnick.
Good afternoon, Judge Flood. Can you hear me okay?
Yes.
Okay. You have admitted that you verbally admonished your staff for not following instructions. Is that right?
I have admitted to what's in the stipulation.
Okay. Does the stipulation include verbally admonishing your staff for not following instructions?
I'll object unless it's shown to the judge. If we're referring to a document, I think it should be shown to her.
Overruled, at least at this point. We'll see what the answer is.
I believe that it contains some language to that effect from my memory.
Right. Let's take a look at it. Judge Flood, do you see the document that's being shared?
Yes.
Okay, I'm going to scroll up to the top. Do you read that it says stipulation to facts and code violations? Did I read that correctly?
I see it.
Okay, did I read it correctly?
I didn't hear everything that you said, but I see it. Yes. So you kind of faded. So
Do you see that it says stipulation to facts and code violations?
in my answer, yes, I see it.
Thank you. Just going to scroll all the way down. This looks like an Adobe sign or a DocuSign. Do you remember electronically signing this document on October 21st, 2024?
Yes.
Okay. Did you also verbally admonish your staff for making mistakes?
I believe the document speaks for itself, ma'am.
So you agreed in this document that you verbally admonished your staff for making mistakes?
I believe the document reads, at times respondent verbally admonished staff for not following her instructions for making mistakes.
Thank you. You also agreed that you communicated with them in a manner that was pointed and harsh, correct?
It says, though respondent rarely raised her voice, her communication could be pointed and harsh.
So you agreed that you did communicate with your staff in a way that was pointed and harsh.
Objection. The document speaks for itself. Asked and answered. Argumentative.
Overruled.
I'd ask the court to direct the witness to answer.
Could you repeat your question?
You admitted that you did communicate with your staff in a manner that was pointed and harsh, correct?
I agreed that it could be.
When you agreed that it could be, did you also agree that it sometimes was?
I believe that it could be.
Okay. You agreed that you could be condescending to your staff, correct?
I object again unless the document is used in reference, Your Honor.
Overruled.
It says, when that happened, when that did happen, respondent could be condescending, which made some staff feel humiliated, embarrassed, and anxious.
I'd ask the answer be stricken as non-responsive and the court direct the witness to answer the question.
I take exception, Your Honor.
I'm denying the motion to strike the answer, but the witness needs to listen closely to the question and answer the questions that's asked.
I'm going to try that again, Judge Flood. So by signing this stipulation, you admitted that you could be condescending to your staff.
Objection is asked and answered, argumentative.
Overruled.
The stipulation states that.
But you don't believe that's really true.
The stipulation is what I agreed to.
I'm asking you a different question. Do you believe that's really true?
I'm not understanding your question.
What part of it don't you understand?
You're asking, what are you asking? Maybe you should restate the question.
All right. You said you agreed when that did not happen, respondent could be condescending, correct?
Say that again. I'm sorry. I'm not
Okay.
understanding if you're asking me if I said something or if the document said something.
Okay. Do you agree that the document says when that did not happen, respondent could be condescending?
Yes, I agree. The document says that. Yes, we have that in front of us. Yes.
Okay. Do you agree that it's true that you could be condescending to your staff?
Same objection, same basis.
Overruled.
Do I believe that this is true? The statement or the stipulation?
I'm going to ask that that be stricken as non-responsive and the witness instructed to answer.
I would take exception.
Yeah, I'm not striking the answer, but clarify the question. Ask it one more time, please.
Okay. Is it true that you could be condescending to your staff?
I believe that that is the opinion of some staff, and as a way to accept responsibility, this is what is in the stipulation.
Okay. Do you agree that the stipulation says you made some staff members feel humiliated, embarrassed, and anxious?
Same objection, same basis.
Overruled.
Can you repeat the question?
Do you agree that the stipulation said you made some staff members feel humiliated, embarrassed, and anxious?
The stipulation says that.
Do you agree that you did make some staff members feel humiliated, embarrassed, and anxious?
That's what I have been told, and that's what I have heard. So
Okay.
I can't control another person's feelings, and I don't know outside of what's been told to me how a person is feeling.
Do you agree that the stipulation says some staff believed that you did not clearly communicate your expectations of them?
Yes, that is what the stipulation says.
Is it true that you sometimes didn't clearly communicate your expectations of them?
I'm sorry, can you repeat the question?
Is it true that you sometimes didn't clearly communicate your expectations of them?
From the information that I have, yes, sometimes because there was clarifications being asked. So yeah, there was sometimes where things were not clear.
The stipulation says that you chastised them if they didn't understand what you wanted. Do you agree that's what the stipulation says?
Yes, that is what the stipulation says.
Is it true that you chastised staff when they didn't understand what you wanted?
That is what was described to me.
Is it true?
Objection is asked and answered.
Ruled.
I need for you to repeat your question.
Is it true?
Under the definition and what was described to me and how people felt, sometimes.
The stipulation says you denied having given unclear instructions. Is that correct?
Yes. Yes.
Did you deny having given unclear instructions?
Yes, that's what the stipulation says.
But did you deny having given unclear instructions?
Yes.
The stipulation says that staff often heard you to respond, "That's not what I said," or "I didn't say that," in response to their concerns. Do you agree that that's what it says?
That's what this stipulation says.
And do you agree that you would respond, "That's not what I said," in response to staff concerns?
Yes.
And how about "I didn't say that"? Do you agree that you would respond, "I didn't say that," in response to staff concerns?
Yes.
The stipulation says that some of your staff became increasingly wary of engaging with you. Do you agree that it says that?
Yes, that's what the stipulation says.
And do you agree that's what happened? That some of your staff became wary of engaging with you?
Yes, that's what some staff has said.
You were a practicing attorney before you were elected a judge, is that correct?
Yes.
Do you agree that it's the job of a practicing attorney to push back on the judge in court?
Objection, form of the question, and it's vague.
Overruled, given the use of that term throughout the direct examination.
No. I believe it's the job of a good attorney, a defense attorney, to advocate for their client. There's a difference in pushback and advocation.
Do you agree that it's an attorney's job to disagree with the court?
Same objection.
Yeah,
I don't know that.
Hang
I'm
on,
sorry.
I'm going to sustain that objection. I'm not sure what that means.
You testified you are a graduate of the Washington Law Institute. Is that right?
The Washington State Leadership Institute.
Okay, thank you for the clarification. You also attended Judicial College?
I attended Judicial College in Reno, Nevada, in the general jurisdiction, and I attended judicial college for the state as well.
And after the CJC contacted you about the complaints, you worked with a coach, is that right?
I worked with coaches throughout my career.
Do you remember, are you familiar with a woman named Talisa Lavari, Lavarry? She goes by Tally, Tali.
Yes,
You worked with Ms. Lavari as a coach, is that right?
I worked with her to do some work with me in the court.
And you chose to work with Ms. Lavari, is that right?
Everyone that I work with, I have chosen to do so.
Is that a yes? You did choose to work with Ms. Lavari?
Yes,
And when you chose to work with Ms. Lavari, that was after the CJC had contacted you about the complaints, is that right?
no,
Your testimony is that you worked with Ms. Lavari before you heard from the CJC about the complaints?
I talked and made arrangements with Miss Lavari before I heard from you.
And did you continue to work with Ms. Lavari after you heard from the CJC about the complaints?
Yes, I worked with a few people after I heard.
And you testified that you've really recently been through empathy training, is that correct?
The training that was mentioned by the court administrator was a resiliency summit with a focus on empathy through a simulation. So it per se, if you want to say that it's an empathy training, then you could say that. But it was a focus on individuals in the system having empathy for defendants and incarcerated individuals and those that have had contacts with the system. So that simulation was based on the role play of being put in jail, having $20 to survive on a month. What do? Do you take a UA for your probation, or do you buy food for your kids? So that was a simulation in empathy for the defendants.
Thank you. Dawn Williams was the court administrator at Bremerton when you took the bench in 2022, is that right?
Yes.
And Dawn had a lot of institutional knowledge as the court administrator, is that right?
Jeff, lack of foundation.
Overruled.
Can you ask your question again?
Dawn had a lot of institutional knowledge as the court administrator, is that right?
Institutional knowledge. Is your question about Bremerton? Is it about a court administrator? Or
Let me come at this a different way. Dawn Williams, is it fair to say she had been the court administrator for 11 years?
I don't know that for sure.
Did you have any understanding of how long she had been the court administrator when you took
No.
the bench?
I did not.
Did you later develop an understanding of how long she had been the court administrator?
I I understood that there had been a previous court administrator to her that she replaced, but I do not know. I did not know the time.
Did you later come to learn that Ms. Williams had been the court administrator for 11 years?
Objection, asked and answered.
Apologies, I couldn't get my clicker. I'm gonna permit the question one more time. Oh, overruled.
What was the question?
Did you later come to learn that Ms. Williams had been the court administrator for 11 years?
Again, I do not know the exact time.
Did you benefit from Ms. Williams' knowledge as the court administrator?
On the things that she shared with me.
I was going to object as soon as facts, not in evidence, because she doesn't know her experience. But the answer, go ahead. I'd say the judge should just go ahead and answer to expedite this.
Yeah, okay. Overruled the objections. Overruled. Go ahead and answer.
On the things that she shared with me.
And in the stipulation, you admitted that Ms. Williams experienced you as constantly critical of her. Is that right?
I don't know if that's something specific or not, but what's in the stipulation is what I admitted to. I'm not understanding why the things that are in the stipulation are what I stipulated to and admitted to, and I'm accepting responsibility for today.
Do you agree that you were at times constantly critical of Ms. Williams?
I object. She stipulated this. It's in the record. It's before the commission. ER 403, waste of time.
I'm going to overrule based upon the direct testimony. Overruled.
Can you repeat your question?
Do you agree that you were at times constantly critical of Ms. Williams?
I would ask that if that's what the stipulation says, for me to be able to see it, because I don't remember everything that is in that stipulation.
I'm not asking you about the stipulation, Judge Flood. I'm asking you if you agree that you were at times constantly critical of Ms. Williams.
Your Honor, I do have to object. If she's referring to a document, it should be shown to the witness. The witness has asked for the document, and she appears to be quoting from it. So that's my objection.
Okay, overruled. Question is not related to a document.
I believe I hear you saying two things. So I'm going to try to answer your question. You said at times, constantly. At times and constantly does not go together. So my response would be, at times I feel and have been informed and am accepting responsibility that Dawn felt that I was critical of her.
Right? You also stipulated that Ms. Williams believed that nothing she could do would satisfy your expectations. Is that right?
I believe that if that's contained in the stipulation, then yes.
Okay. Do you agree that it was difficult for Ms. Williams to satisfy your expectations?
I don't know. I don't think I can answer that question. I believe she may have felt that way, and I can acknowledge that she felt that. I can't do any more than that.
Judge Flood, you reached out to Courts Helping Courts in September 2022. Is that right?
Yes.
And you asked Trish Kinlow for help at your court. Is that right?
Yes.
And you told Ms. Kinlow that you thought the trouble at the court was because of racism. Is that right?
Not specifically in those terms.
How did you put it when you told Ms. Kinlow that?
I believe the conversation was, I was concerned because of an incident that happened with an employee calling me by my first name, and that I'm experiencing micro and macro aggressions in the behavior of the staff, and that I was told to reach out to her, that there could possibly be some support that she may know about, and to ask her for assistance. She told me that I should definitely talk to HR and send an email to Courts Helping Courts. And then I don't know if we scheduled a follow-up after that.
Okay, I'm going to ask another question. All right, I'm mindful of our time. I don't mean to cut you off, but I'm very mindful of our time.
Your Honor, I object. She should be allowed to finish her answer.
I'm going to permit the question, another question to be asked.
Okay. Who suggested you reach out to Courts Helping Courts?
A judge friend.
Who was the judge friend?
I believe it was Judge Chess.
You mentioned that you had told Trish Kinlow that you were experiencing microaggressions and macroaggressions. Is that correct? Did I get that right?
Yes.
And microaggressions and macroaggressions are racism. Is that right?
They're forms of biases
Are they forms
that
of?
are,
I apologize. Go ahead.
so to answer your question, it's forms of that fall in that category of inequity, racism, biases, implicit biases, explicit biases. Overall.
This is what you told Ms. Kinlow.
It was in conversation, so it was a general, fast conversation. It wasn't getting into any details as to who I was saying that it was from. I said I was experiencing it at the court.
Okay. And was it your impression that Ms. Kinlow understood you to mean you were experiencing racism at the court?
I don't know what Ms. Kinlow took from that other than me asking for help.
Okay. And Ms. Kinlow is a Black woman, is that right?
Yes.
When Ms. Kinlow and Jennifer Johnson came over to Bremerton Municipal Court to help, you welcomed them, is that right?
Yes.
You were really happy to see them, is that right?
I was relieved.
You were relieved to see them. Did I hear you correctly?
Yes.
Do you remember saying to them that they were your guardian angels?
I was referring to the program of Court Helping Courts as they were there representing Court Helping Courts. So yes,
Okay.
in that context. Context.
And Ms. Johnson is Black and Mexicana. Is that right?
That's what you have in the paperwork. She told me she was Puerto Rican.
Okay. Do you have any reason to think that she's not Black and Mexicana?
She told me she was Puerto Rican.
I see. Do you believe her that she's Black and Mexicana?
I believe what she told me. So I believe that in the Latin, American, Mexican American, when you're talking different cultures and countries, some people who are of mixed descent like that refer to themselves at times as Puerto Rican. Some of them refer to themselves as time as Black and Mexicana, as you're describing here. But what I'm saying is she told me she was Puerto Rican.
Thank you. As the judge at Bremerton Municipal Court, you get to decide whom to hire as court administrator. Is that right?
Yes.
And you decided to hire Jennifer Johnson as court administrator. Is that right?
Based on the recommendations from the hiring panel. I put together a hiring panel for the court administrator's position after Dawn left to replace her. I hadn't made any decisions prior to that. And in putting together that hiring panel, both Trish Kinlow and Jennifer Johnson agreed to be a part of that hiring panel. So Jennifer Johnson was actually a part of the hiring panel. She then asked Miss Gale, can't remember what court she's from, to replace her on the hiring panel. After applications began to come in, she then emailed and said that she was going to apply and asked Gail to replace her on the hiring committee.
But the decision to hire Jennifer Johnson as court administrator was yours in the end, correct?
I took the advice of the hiring panel. My ultimate being the one that signed the letter, I was the only one that could sign the letter. I was the only one who was on staff at the city. So my hiring panel made a recommendation and I adopted that recommendation.
Thank you. You could have contacted Judge Leone as a reference check for Jennifer Johnson, right?
I could not contact Judge Leone because Jennifer Johnson did not give me her telephone number. And she told me that Judge Leone was on bereavement leave and not available. So I could not contact her.
Your testimony is that Jennifer Johnson prevented you from contacting Judge Leone?
My testimony is that I did not get the telephone number for Judge Leone from Jennifer, that Jennifer Johnson told me that Judge Leone was on bereavement leave. That is my testimony. So I did not get a chance to talk to Judge Leone before I hired Jennifer Johnson.
You didn't take any steps to try to locate Judge Leone's contact information?
I did not want to, if being respectful that she was on bereavement leave, I did not want to impose during that time.
You saw the former probation officer, Ian Cohen, testify earlier this week. Do you remember that?
Yes.
Do you remember seeing Mr. Cohen break into tears a couple of times while he was testifying?
I saw him wiping his face.
You just sort of smiled a little bit. Why did you smile when I asked you about Mr. Cohen breaking into tears?
Because your description is breaking into tears. I saw him wiping his face. So that's a difference of your opinion is that he broke into tears. My opinion is that I saw him wiping his face. I wasn't watching his every move. So descriptions are very important. And your of course, the prosecutor. So your description is one of a prosecutor's.
Thank you. Do you agree that the stipulation states that Mr. Cohen experienced you as constantly critical of him?
Objection.
I know the
Like a foundation speculation, she's asking what he thought and what he perceived. And the stipulation speaks for itself and should be shown to the witness in any event if it's being used.
Well, I'm going to sustain the objection unless the question is, does she, it's to me a fair question whether she remembers what's in the stipulation. But if you're going to ask her if it's in the stipulation, that to me needs to, I'm going to sustain the objection with respect to that being an aspect of the question. I'm not sure I understand the question.
Okay. I will try it again. Judge Flood, do you recall that the stipulation states Mr. Cohen experienced you as constantly critical of him?
Same objection, same basis.
That one's overruled.
Can you please ask your question again?
Judge Flood, do you recall that the stipulation states Mr. Cohen experienced you as constantly critical of him?
I do not recall specifically what the stipulation states as to Mr. Cohen.
Okay. Let's take a look at it. Are you able to see the document?
Yes.
Okay. I would direct your attention to the first sentence of paragraph F. Does that sentence say that Mr. Cohen experienced you as constantly critical of him?
Objection unless it's read in its entirety and context.
Overruled.
So from my read of it, the probation officer, Mr. Cohen, also experienced respondent as constantly critical of him and believed that nothing he could do would satisfy respondent's expectations. Yes, that's what I agree to, and that is the full sentence.
Okay. Were you critical of Mr. Cohen?
In the sense of bringing things to his attention that needed to be corrected, that is termed as critical, yes.
And did he have difficulty meeting your expectations?
From my understanding, yes.
Was your experience that he had difficulty meeting your expectations?
In some conversations with Mr. Cohen, he would say, Judge, I'm trying to not do things the way that Judge Doctor did them, but trying to learn your new way of doing things. So with that leads me to believe and admit to in these proceedings that he had difficulty. Because again, he said he had done things for so long, Judge Doctor's way and the way that things go, that he had difficulty making changes.
All right. I'm looking a little bit farther down in that same paragraph F now at the beginning of the next page. This sentence says that Mr. Cohen felt humiliated by your treatment. Do you see that?
Yes.
You agree that Mr. Cohen felt humiliated by your treatment?
Objection, speculation, and what he felt, or that she can agree to it.
Overruled to the question, to the narrow question, overruled.
What was the question?
You agree that Mr. Cohen felt humiliated by your treatment. Is that correct?
Again, the stipulation language is based on what I have been told as to how he felt. And it states that Mr. Cohen felt humiliated. So That
right?
is what I am agreeing that he has said that he felt. So yes, but I can't
Right. Thank you.
determine another person's feelings.
Thank you,
I
Judge
can't
Flood.
testify and say, I know only that person has their feelings.
Thank you, Judge Flood. I'm going to move on now. You hired Serena Daigle to work for Bremerton Municipal Court. Is that right?
Yes,
You
Serena
hi-
came to us through court helping courts as well.
Right. And then you hired her to work for the court. Is that right?
Yes, Serena indicated that she, through text messages, she wanted to be my sidekick. She had hoped to be the court administrator.
Okay. And you agreed that she would be a good fit as an employee of the court, so you hired her.
Actually, I first interviewed Serena for a court administrative position. The panel said that she would not be a good fit.
So you hired her for a different position.
I then listed the position of senior legal technician, and Jennifer Johnson wanted to bring her on. And so Jennifer Johnson wanted to work with Serena because she said she had worked with Serena at Des Moines. My choice for that senior legal technician was different from Jennifer's.
But you agreed to hire Serena.
Yes, because the court administrator said that she had the experience and could work with her.
Right. You agreed in the stipulation that you spoke to Serena Daigle in a manner that she felt was impatient and discourteous. Is that right?
I believe the stipulation says on one occasion when Ms. Daigle was filling in the courtroom and Ms. Daigle asked the respondent to clarify a ruling in court, respondent spoke in a manner Ms. Daigle felt was impatient and discourteous.
Do you agree that you spoke to her in a way that was impatient and discourteous?
Objection, asked and answered.
Overruled.
I believe that she felt the response was discourteous and impatient.
You admitted raising your voice and yelling across the clerk office at Amber Dodge on that incident that you talked about during your direct exam. Is that right?
No,
You did not admit that you raised your voice and yelled across the clerk's office at Amber Dodge.
I object, it's asked and answered.
Sustained.
Did you stipulate that you shouted at Amber Dodge across the clerk's office?
I believe there's language in the stipulation. If you want to refer to that, you should bring it up.
All right. I'm looking at paragraph NA, which starts on the bottom of page 4. I'm looking at this sentence. So you admitted that in a raised voice, you shouted at Ms. Dodge, "I have been waiting in the Zoom waiting room for over 10 minutes. Will someone please let me in?" Is that correct?
Objection unless the rule of completeness, the full sentence, paragraph, context isn't being shown are referred to.
Well, the entire paragraph is being shown.
It-
What aspect of the paragraph is not complete with respect to the sentence that was read?
Well, anytime, Your Honor, that it's not read for the full sentence, just part, I think is a proper objection.
Did you read the full? I'm sorry to interrupt. Did you read the full sentence, Ms. Rasnick?
I did not, but I certainly can. But the full sentence is visible to everyone.
That's my objection, Your Honor.
Okay, read the full sentence, please.
Sure, I'll rephrase the question. Judge Flood, did you admit in the stipulation, standing in the doorway at the other end of the room, respondent in a raised voice shouted at Ms. Dodge, "I have been waiting in the Zoom waiting room for over 10 minutes. Will someone please let me in?"
Same objection. There's, unless I'm not seeing this correctly, it looks like there's a dash before the standing and there's further language before that.
Overruled. That dash looks like a footnote.
Like a what, Your Honor?
To me, it looks like a footnote. Objection's overruled.
Oh, all right, thank you.
So what the stipulation states is raised voice and shouted, not yelled. And I was standing in the doorway. I was not in the room. Because as I described, the stairs come right down to the doorway, and I was a bit winded. They were on the other side of the office. I did not step into the clerk's office. So it was a raised voice. And because I was standing in the doorway, and then yes, you have the shouted, because I'm in the doorway, I'm not in the room. So to answer your question that you're saying from the other side of the room, no, I was in the doorway. And yes, as to the raised voice and the language there where it says, I've been waiting in the Zoom room for hearings to start for 10 minutes. And that's what I testified to, that I was trying to start court.
You heard Latricia Kinlow's testimony that Amber cried after you shouted at her, right?
I heard the testimony, yes.
Did it surprise you to hear Ms. Kinlow testify that Amber cried?
Yes.
And you heard Ms. Kinlow's testimony that she had never heard a judge speak to an employee like that. Did you hear that?
Yes.
And did that surprise you when Ms. Kinlow testified that?
Yes.
Do you recall an employee named Brian Knowles, Knowles?
Yes.
You hired Mr. Knowles, is that right?
Yes.
Mr. Knowles is Black?
Yes.
And you admitted that you were impatient and discourteous to Mr. Knowles, is that right?
Same objection in the stipulation and it being properly shown to the witness.
Overruled.
If you can state your question one more time.
You admitted that you were impatient and discourteous to Mr. Knowles, is that right?
I believe there is a paragraph in the stipulation that Mr. Knowles is discussed with a particular incident in I believe Ms. Johnson's office. So I do believe that there is some language there, yes.
But you don't remember admitting to being impatient and discourteous to him?
I don't remember the exact language that is in that paragraph, but I did stipulate to the language that is in that paragraph.
All right, let's look at that. Right, I'm looking at page 5, paragraph C. It starts on the bottom of page 5. You stipulated that when Mr. Knowles began to stand up, you told him firmly to sit down.
Again, I
Is
object
that correct?
I object unless a full sentence is read, Your Honor. It's part of a sentence.
Well, can you read the full sentence, Ms. Rasnick?
You stipulated respondent told him firmly to sit down. Is that correct?
That's not the full sentence, Your Honor.
I don't know where you I don't know where you're at.
Okay.
I'm sorry. I don't.
Let's look at page 5. Do you see page 5?
Yes.
Do you see line 20 of page 5? Right here. Do you see my cursor?
Yes, but that's not the beginning of the sentence.
That's right. I think we have been through this before. Do you see the sentence that says respondent told him firmly to sit down?
Same objection.
Overruled.
Yes, I see the sentence.
You stipulated to that, correct?
Yes.
The next sentence says, I'm looking at the very next sentence. Respondent admonished Mr. Knowles, then remarked that the admonishment had been a teaching moment for him, period. You stipulated to that, correct?
Can you pull the full thing on the screen?
Sure.
All of the paragraph.
I'm doing it right now. On the full paragraph.
Mhm.
I think that would make it pretty small, but sure.
So
There you go.
I believe paragraph C is in reference to Brian Knowles. And I stipulated that in February 2023, respondent called Jennifer Johnson, whom she had hired as a court administrator in November 2022. And Brian Knowles, a legal technician, when respondent had hired him in December 2022 into Ms. Johnson's office. Respondent asked Mr. Knowles about an issue with a judgment and sentence he had completed while working with a remote pro tem judge. Mr. Knowles began to stand up. Respondent told him to firmly sit down. Respondent admonished Mr. Knowles, then remarked that this admonishment had been a teaching moment for him. Respondent now recognizes she talked to Mr. Knowles in an impatient and discourteous manner. That is what I am acknowledging and have stipulated to.
Right? Part of that stipulation is that you talked to Mr. Knowles in an impatient and discourteous manner. Is that correct?
That is included in that paragraph, yes.
You heard Jennifer Johnson testify about this incident in her office with Mr. Knowles. Is that right?
I don't remember that testimony.
You saw Ms. Johnson cry when she testified about this incident. Do you recall that?
No. I don't recall the testimony about this incident, so I can't recall her crying about it. There was a lot of testimony. I do recall Ms. Johnson wiping her face and holding her head down and asking for a moment, but I do not remember what part of the testimony that was.
Right. Were you acquainted with a gentleman named Maury Baker? Maury, Maury Baker.
What is the question?
Are you acquainted with him?
Yes, I know more. Baker.
And he volunteered his time to help out at Bremerton Municipal Court. Is that right?
Mr. Baker reached out to the mayor, asked the mayor and to pass on his contact information to me. Me and Mr. Baker met for coffee in Silverdale and talked. And he said that he would be willing to help with training a court administrator, as I was aware that he had been a retired court administrator for Kitsap County.
And Mr. Baker then came in and volunteered in the courthouse for several months. Is that right?
2 months.
You appointed him some sort of an advisor to the court. Is that right?
He asked to work in an advisory capacity.
And you
And he
appointed.
asked,
Go ahead, Judge Flood.
he asked to work in an advisory capacity. And he said that he didn't need to be paid as an interim or anything. So, because he was retired and he just wanted to help train, again, the staff and the court administrator.
So you accepted Mr. Baker's help. Is that fair to say?
Yes,
You welcomed him when he offered to help you. Is that fair to say?
I invited him in. So I'm not, when you say welcome, it was my invitation.
And when Mr. Baker stopped volunteering in August of 2023, he conveyed to you that the court was as good as it was going to get under your chain of command. Is that right?
Me and Mr. Baker did not talk before he left. He told me he would see me the next day, and he did not see me the next day. At the end of that day, I was sent a message from HR that he had announced that the end of the day would be his last day. So I did not have a conversation with him. What you're referring to, I learned from HR.
Right. I'm going to share a document that's been identified as Disciplinary Counsel's Exhibit 226. Take a look at this, Judge Flood, and let me know if you have seen it before.
I didn't hear your question.
Okay.
What did you want me to tell you?
Mr. Baker says in this letter that it's been an honor to work with the staff of Bremerton Municipal Court, past and present. Do you see that?
Yes.
And then he goes on to say, as of the writing of this letter, I can report that the court's current level of functioning is as good as it will get under your chain of command. Do you see that?
Yes.
And then he goes on to say, I sincerely believe that you desire to lead the court in a positive direction in order to serve the best justice for the citizens of Bremerton. Do you see that as well?
Yes.
And then he concludes, it is my conclusion that your decisions and behavior are not conducive to that goal. Did I read that correctly?
Yes.
Did you receive this letter from Mr. Baker?
No, I didn't receive it from him. Again, I received it from HR.
Okay. This is the letter you received from HR.
Actually,
I'm going to offer.
Eventually I received it. I believe
All right.
maybe an electronic version or something in an email with this information in it.
Okay.
With the
Just scanning all the way up and down.
with the PAF.
Appreciate it. Disciplinary counsel offers exhibit 226.
Objection. Foundation.
You're muted, Your Honor.
Okay. Thank you. I was going to say I have not asked for your response yet, Ms. Bremner. I was going to say, as I always do when an exhibit is offered, 226 has been offered. Ms. Bremner?
Foundation objection. Relevance 403.
Ms.
Hearsay.
Rasnick,
And hearsay.
Ms. Rasnick, your response?
The witness has testified, the witness has authenticated the document, has testified that she recalls receiving it. It is probative of issues that are in controversy, as Ms. Bremner has repeatedly used as the basis for admission of documents, and it's being used on cross-examination.
I haven't used any documents.
Well, the document was appropriately used as an impeachment exhibit, but admitting it as substantive evidence is not something that would be appropriate. I'm going to sustain the objection.
Right.
And we'd like to, if we could ask the court to advise the panel to strike.
I'm not going to strike the exhibit. I will tell the panel that it was used for impeachment. You're not to view the letter or recall the letter as substantive evidence.
Thank you, Your Honor.
Let me ask about Serena Daigle again. When Serena Daigle, do you recall Serena Daigle resigning in May 2023?
I don't know the exact date of when she resigned, but I do recall that she had hired an attorney, and there was some back and forth with her asking for some accommodations. And the response was that the accommodations didn't come in time, but I don't know the exact date.
Do you recall Ms. Daigle testified by declaration that she resigned after consulting with a physician? Is that correct?
Objection based on hearsay and not shown to the witness.
Can you repeat the question, Ms. Rasnick?
Sure. When Ms. Daigle resigned, she said she was doing so after consulting with a physician. Is that right?
Same objection.
Yeah, I'm going to overrule the objection. It doesn't go to the truth, in my view, based on the purpose of the questioning.
Sure. Do you recall, Judge Flood, Ms. Daigle communicating that she was resigning after consulting with a physician?
I do not know as to any specifics, as at that time, Ms. Daigle was represented by an attorney, and I believe the communications were going from the counsel assisting the court and her counsel and the interim or the assistant court administrator at the time. So I can't say specifically.
And in her resignation letter, Ms. Daigle called the work environment at Bremerton Municipal Court hostile. Is that right?
Objection calls for hearsay.
I'm going to sustain the objection. I'm not sure where the foundation for the question is coming from.
Do you recall seeing Ms. Daigle's resignation letter?
I do not specifically.
Did Ms. Daigle ever communicate to the court that the work environment at Bremerton Municipal Court was hostile?
Not that I can recall.
Let's take a look at this document?
I'll object to this being shown to the panel, Your Honor. It's hearsay, and it's being shown right now without, I understand the problems with this format, but it is hearsay. And there is actually a way to, in my experience in my trials, whether it's electronic trials or in person, that you can show that to the witness first electronically before showing it to the jury or the panel.
I'm going to overrule the objection with respect to the format. We've been doing it this entire way, and an objection this late as to the format will we're not going to change what we're doing here this late in the game. However, if the matter is not admitted, I'll appropriately instruct the panel with respect to the way they treat the exhibit.
And I would just indicate I'm not being delayed on this. It's just that these are the first times I felt there should be an objection to these being shown to the jury. So that's all I have to say. Thank you.
Judge Flood, does this refresh your recollection of what Ms. Daigle communicated to the court?
No, it does not. This letter is not addressed to me. And there were several resignations that I rarely saw that would be received, and I was just told that they were received.
Right? You testified that you didn't recall this is a letter directed to Bremerton Municipal Court. This does not refresh your recollection of what was communicated to Bremerton Municipal Court.
This letter is addressed to Jennifer Johnson, Bremerton Municipal Court. It was not addressed to me, and I do not recall receiving it. And you showing it to me now does not refresh any memories from May 10th of 2023.
All right, I will move on.
I'd ask the court to admonish the panel to disregard that item.
Well, I'll instruct the panel. I will not admonish the panel. The panel will be instructed not to recall anything with respect to what they may or may not have seen with that exhibit.
And admonishment is probably the wrong word. Thank you.
Admonishment is a pretty strong word, it's true. Christina Rauenhorst applied for the court administrator position about the same time as Jennifer Johnson did. Is that right?
They did apply at the same time.
And you later hired Christina Rauenhorst as a senior legal technician, is that right?
After she interviewed for that position.
She interviewed for the court administrator position?
She interviewed for the court administrator's position, and she interviewed for the senior legal technician position.
Okay. Did you want to hire her as court administrator at the time that you ended up hiring Jennifer?
She was a good candidate, and that she was discussed amongst the panel as one of the options.
Christina Rauenhorst is the current court administrator, is that right?
Yes.
Okay. Would you describe yourself as being at the top of the hierarchy of authority at Bremerton Municipal Court?
As the presiding judge of a one court with the part one half day or 0.5, a little bit under 0.5 commissioner and a court administrator. So yes, so the way that the court is set up is the presiding judge, our court administrator, our services support specialists, probation department, 2 seniors, 2 legal technicians, 2 legal technicians, 1.
And were you?
And then we have security staff that is on contract, 2 different contracts for armed security and merchant services for screening security.
And was the list you just read kind of in order of authority? So yourself, and then the court administrator and so on? Was that in descending order of authority?
That is the current setup of the court. Yes, as far as the flow chart and how things flow and the organization, no chart. Wow. But as a part of this, because of the city government above me, and because it's a city court, is the mayor and the city council.
In your direct exam, you referenced GR 29. Did you mean General Rule 29?
Yes.
And that rule says that the presiding judge has authority over the court employees. Is that right?
I believe if we're just summarizing that that says the presiding is responsible for all things under the court, I think except for salaries.
Okay.
But in essence, I believe overall, my reference was all things.
Okay. So you're bound by GR 29.
Yes.
That's a source of your authority, GR 29.
Yes, and all other general rules and codes and RCWs. So yes.
Okay. You have a pending legal action against the city of Bremerton alleging that they owe you back pay. Is that right?
My pending legal action against the city of Bremerton is in regards to my pay.
Okay. Is it your
that
contention?
My pay has not been raised since 2022, that the city of Bremerton was a part of the court improvements grant plan, and that a part of that plan was that elected judges' salaries that were part of that program be paid in conjunction with the judges' salary commission, and that at a minimum it be 95% of a district and superior court judge's salary.
Okay. And one of your claims in that lawsuit is that you should receive back pay. Is that right?
I cannot say if that is a specific claim, but ultimately, I believe that it's inferred that if I have not received pay increase since 2022, because the city council tabled my pay and told me that they could reduce my pay to $80,000 if they wanted to, then that is a part of the claim.
Okay. Have you ever been accused of contributing to a hostile work environment in an organization?
Objection, lack of foundation. Form of the question, I think, and cultural legal conclusion is to hostile work environment, which is generally based on, well, I'm not getting any other details. I think it needs to be defined if the question is going to be asked.
Overruled.
I'm waiting for a question.
There's a question pending, Judge Flood.
I think you should repeat it because I didn't hear it with the objection and the fuss. So sorry. Would you please repeat the question so that I can answer?
Sure. Have you ever been accused of contributing to a hostile work environment in an organization?
Don't know what you're referring to.
In 2021, while you were the president of the board of directors of Kitsap Community Resources, their leadership team accused you of creating a hostile work environment for staff. Isn't that right?
Objection, beyond the scope, lack of foundation, assumes facts, counsel's testifying.
Overruled.
I again don't. I do not believe that is correct.
Were you president of the board of directors of Kitsap Community Resources in 2021?
Yes, it was.
Is it your testimony that the leadership team of Kitsap Community Resources did not write to the board of directors accusing you of a hostile work environment for staff?
Objection, assumes facts, asked and answered. Beyond the scope of direct.
Overruled.
I'm sorry, I didn't hear you, Judge.
I said overruled.
My testimony is that I do not believe your statement is true. That as to what you're saying there, I believe that there was information sent to the board through another source.
Let's take a look at this document for a second. I'm sharing what has been identified as Disciplinary Council's Exhibit 219. Judge Flood, have you seen this document before?
Not in this format.
Was Irmgard Davis a person who was affiliated with Kitsap Community Resources when you were the board president?
And I object and ask to have this taken down. It's all hearsay. It's beyond the scope. It's not relevant to these proceedings. She's just shown the whole thing to the panel.
I'll instruct the panel appropriately at this point. You continue to ask your questions, Ms. Rasnick. I'll overrule the objection.
So the question, Judge Flood, was Irmgard Davis, whose signature is right here, affiliated with Kitsap Community Resources when you were the board president?
Yes.
And in this letter, Irmgard Davis and the other signatories are accusing you as board president of creating a hostile work environment for staff,
Your Honor,
bullying and intimidation tactics.
Wait a minute.
Is that what the letter says?
I object. It's hearsay. It shouldn't be shown.
This is impeachment.
Your Honor, I'm sorry. It's still speaking. This going through and reading from it when it's not an admitted exhibit is my first objection. Second is it's not proper impeachment in this case. Third, it's beyond the scope of direct examination. But you can't just start reading from a document that isn't even in evidence. Yet there it is right in front of the panel.
Okay. First, given the breadth of statements made during direct, this is, in my view, a fair impeachment. Secondly, it is impeachment. And so narrowly, Ms. Rasnick, and this goes to you, you're only going to appoint reference statements that are impeaching. And this one that you have read is impeaching. Beyond that, I don't want you to go further than that. And I do want you to limit the amount of exposure this document has to the panel. I am going to appropriately instruct the panel regarding its use as impeachment, not as substantive evidence. But I want you to be, there is some merit to having this document up for an unduly lengthy period of time, or to read from it for purposes that go beyond the narrow impeachment that you're trying to use it for. With that, let's continue the questioning, but please be direct and appropriate and efficient.
Judge Flood, do you see the first sentence on the page that's displayed right now, indicating that the signatories of the letter are accusing you of creating a hostile work environment for staff through bullying and intimidation tactics? It goes on to list such as cutting off staff mid-sentence during presentations and discussions, discussing personal opinions of a management member with other staff members, lack of communication regarding meetings, in-person visits and information directly affecting staff members, singling out staff members for unprofessional and degrading discussion, setting expectations for staff members not consistent with her position, e.g., expecting a staff member to respond to a demand or request from her, thus violating bylaws. Do you see that bullet point?
I have said in my testimony that I have not seen this letter and the way that it's being presented here. When I was running for judge in 2021, and this letter references when I was running for judge, this letter came out during that campaign that this was going on. In the way that you're reading it and the way that it's being presented, and it was put in the paper. The way that it was presented to me as board president was through the Kitsap Community Resources attorney, who had basically, the best way to put it is, put out a letter to the board representing the staff against the board pertaining to the hiring committee for the new executive director, which I was elected and nominated to lead the hiring committee panel. This letter references that hiring committee panel. So when I say that I did not, and I'm not familiar with this letter in this setting, in this format, that is what I'm explaining to you, that this was put in the Bremerton Sun. It did not come to the board in this format.
So you saw this letter in the Bremerton Sun?
Yes.
Okay.
Oh, I apologize. It's not the Bremerton Sun. I've been around 30 plus years. It was the Bremerton Sun. It was the, you're not understand what it's the Kitsap.
It's the Kitsap Sun.
Yes, so
I do that too. Yes.
Ms. Rasnick, you're not offering that exhibit.
I am not offering that exhibit. That exhibit is for impeachment. To the extent that the panel is being provided with exhibits that have been used for impeachment, I would like them to see that exhibit as well. But I'm not offering it as substantive evidence.
I would object to it being shown to the panel as impeachment, Your Honor.
Well, at this point, the panel has seen it with respect to impeachment. And I will instruct the panel that that letter is not substantive evidence. It's not admitted as substantive evidence. You shall not consider it as substantive evidence as to the truth of the statements made within the letter. It was used for impeachment, which is an appropriate use of that letter. All right, go ahead, Ms. Rasnick. Ms. Rasnick, maybe I can ask you at this moment where you are. We're rapidly hitting the 90-minute mark of your cross-examination, and I'd like to get a sense of your timing.
I am almost done.
Okay, please proceed.
I am almost done. Judge Flood, your deposition in this case was originally ordered set for November 6, 2023. Is that right?
I don't recall specifically.
Do you recall your deposition being ordered set and then being ordered set for a different date?
I don't recall specifically.
Do you recall your deposition being set to occur on January 10th if counsel didn't agree to another date?
I know there was a few dates, but I again, I don't recall specifically. I remember there being a lot of dates and scheduling issues, and then
Do you recall your deposition starting on February 7th?
I object beyond the scope, 403 relevance.
Overruled.
Do you recall your deposition being started on February 7th?
I do not recall the specific dates.
Okay.
I do remember it was sometime in February.
Do you recall?
Beginning.
Sorry about that. I didn't mean to speak over you. Do you recall your attorney, Vonda Sargent, suspending the deposition after about 20 minutes?
I object to this, same basis.
Overruled.
I remember there was a back and forth between you and my attorney, Vonda Sargent, at the time, that there was an inquiry made into the people who were in attendance and if everyone who was in attendance should be there. I remember there was a back and forth about the questions that you were asking, similar to these proceedings now, objections being made. And the purpose of the deposition and me being ordered to testify and give testimony against myself. She wanted to make a record. You wanted to make a record. There was a back and forth. So I don't know if that was more than 20 minutes, less than 20 minutes. It seemed like a lot of there was a lot of back and forth in my opinion. So
do you recall your attorney, Vonda Sargent, then moving for an order claiming that you shouldn't be deposed at all?
Objection, foundation, calls for hearsay. Relevance.
Ms. Rasnick, a lot of this information is already in the record. Where are you going with this?
Sure. One of the factors that the panel is going to have to consider to determine sanction is the respondent's compliance or lack thereof with this proceeding. And I have just a few questions to ask the respondent about this proceeding and her participation in it.
Ms. Bremner?
Your Honor, plus we weren't even part of that, so that's another layer of objection. But I don't think what the lawyer did at the time should be used with respect to the issue that's just been stated by counsel on cooperation.
With that, I'm going to overrule the objection. Go ahead.
Judge Flood, do you recall your attorney moving for a protective order so that you would not be deposed at all?
I recall several motions being made about these proceedings and being able to defend against these proceedings while defending against the proceedings, being accused of not being cooperative in the proceedings. That's what I remember.
Do you recall that the disciplinary hearing was previously set to begin on March 18th, 2024?
I remember the disciplinary proceedings were supposed to start in November of 2023.
You don't recall an order
I-
setting the proceedings to happen beginning March 18th, 2024?
These proceedings have been continued and been around for a while. My remembering in that is that they were originally set for November of 2023, or the fall of 2023, or 2022. But I remember that there's been several notices regarding panels being changed. So there's been several notices. Believe then it was set again, and that it was set in March of this year. So I believe this has been set more than one time.
Do you recall your attorney asking to delay the March hearing based on?
Objection is beyond the scope, hearsay.
Overruled.
Do you recall your attorney asking to delay the March hearing based on your medical condition?
I recall that I would not be available for one of the hearing dates for a medical appointment.
Do you recall
And
that I'm sorry, Judge Flood, your name is appearing over your mouth in the way I'm seeing you, so I cannot see when you have finished speaking.
Oh, okay. Can you,
that's better, thank you.
Okay.
Or if you could sit up a little bit.
I'm a little.
I understand.
It's a big chair, sorry. And I'm trying to sit up there. So
I think I needed to ask another question.
okay.
I think you finished asking the question. At the time that your attorney asked to delay the hearing based on your medical condition, your attorney didn't provide any documents to substantiate the medical condition. Is that right?
Objection calls for hearsay. Relevance is beyond the scope, and her medical condition is not at issue in this case. And privacy. HIPAA.
I can't think it's hearsay, but at this point, Ms. Rasnick, this is part of the record in this case. Unless you've got something that goes beyond what's already in the record in this case and amply documented in multiple orders. Perhaps there's an angle here with Judge Flood that you're trying to get at that I don't understand, but be efficient. I'm going to overrule the objection, but again, I don't know that you need to trod ground that's amply in exhibits in the orders.
All right. Judge Flood, you were ordered on several occasions to provide information about your medical condition. Is that right?
I was ordered to give updates on several things.
Some orders were entered reflecting that you had not complied with the orders to disclose the medical information. Is that right?
I don't remember every specific order of the presiding here. The judge asked me to do some updates. I provided those updates. Counsel did not see my updates as sufficient. Counsel then wanted to obtain my medical records through subpoena. The VA hospital said that that was going to happen. I provided the documentation to support the information that I had available to me at each junction that I was told to do. I provided what I could when I could provide it at those times. And in my opinion, it was sufficient. In your opinion, it was not. The judge ruled and did not do a subpoena in the end. It was also put in the newspaper that I was not cooperating. All of the information was sent to the Kitsap Sun again, that the judge was ordered to do something and she was not complying.
And you told the Kitsap Sun in August 2024 that you never said anything about a medical condition to the commission. Is that right?
Objection, hearsay.
Overruled.
I'm sorry, I'm not understanding your question.
You just mentioned that the Kitsap Sun had covered the issue of the delay in the proceedings because of the medical condition. You mentioned this, that it came up in the Kitsap Sun. You told the Kitsap Sun in August 2024 that you had never said anything about a medical condition.
I never told the Kitsap Sun that they put in the paper what they wanted to put in the paper. My declarations and sworn declarations to the court is what my statements were and what I provided. Whoever the court reporter was, they pick and choose what they want to put in the paper. Whatever sells headlines is what is put in the paper. And again, as I said, that this has been a public lynching. The whole thing, even with the Kitsap Community Resources letter, and as president of the board, there was an independent investigation with 19 witnesses. I was given an award at the end of my term. I finished my term. So all of these allegations that came forth that was put in a paper when I was running was not proven. And none of that was published. But the attack on the eve of the election was. And the people in my community, the people who have worked with me outside of those individuals at KCR, and everybody knows KCR has had a reputation in our community to be an institution that has had issues. They had an issue with the person who was selected as the executive director being a Black man. That was their issue with me. The issue with me was that I put together an independent hiring committee from the community because it's Kitsap Community Resources. The hiring committee needed to be representative of the community for this leadership position.
Just have a couple more questions. Judge Flood, earlier,
A moment, please.
Of course. Sorry, Your Honor, I'm not sure what has happened. I don't see Judge Flood on camera.
Your Honor, she's taking a second and composing herself.
And just for the record, she appeared to be very upset and turned off her camera and said something like, "I need a moment," or something like that.
All right, appears that Judge Flood is back with us. Ms. Rasnick.
All right. Judge Flood, earlier today, I believe it was today, you testified that you were handling a matter on the record in Bremerton Municipal Court this past Monday, October 21st, from 8 a.m. until about 8:27 a.m. Is that right?
Isn't it Wednesday?
No, that would have been Monday, October 21st.
I was on the record in my court for our video and custody calendar on Monday at 8 o'clock. And I gave the reasons why.
You testified earlier that you were handling an order for a therapeutic court participant. I just want to make sure I'm tracking that. Is that correct?
When I came on the record, I asked the jail to please bring Mr. Sampson in because he was not there and he is the therapeutic court participant who I wanted to have heard.
Thank you. But a court commissioner was available who could have signed that order regarding Mr. Sampson, right?
Sims facts, objection.
Overruled.
A court commissioner could not have handled the order the way that it needed to be handled, as all of the matters dealing with our therapeutic court committee and participants, there's additional details how the orders have been handled. And so she did not have that information, and I did not have all of that information until that morning.
And when you logged on to the hearing about 8:40, you said you had not had an opportunity to review the proposed stipulation. Is that right?
Objection, this is all beyond the scope, Your Honor, and counsel's testifying as at the time.
Overruled.
I said that the stipulation, as I recall, had not come in to me before 8 o'clock. So the stipulation came in from my review of my emails after and while I was logging in to the proceedings that was set to start at 8:30.
Do you recall that we had been instructed to log in at 8 a.m.?
I do not recall that.
That's all I have on cross, Your Honor.
No questions, Your Honor.
Ms. Rasnick, and thank you, Ms. Bremner.